recording.
Thank you, Jose. And thank you to the Redistricting Data Hub for allowing me this opportunity to begin one of this series of, I think, about 3 trainings. This one specifically focuses on the Voting Rights Act, and the more in-depth racially polarized voting will come. But this is important because it's going to be good to engage and understand why you're going to have to do the racially polarized voting. So this is going to place it in context, and I hopefully I can get you there, and by the end of the hour you can be like, okay, I get why we have to do this and why I need these election returns and why I need this census data and all of that. I'll try to keep it interesting before we get to the Q&A so I don't lose you. I'm sure everyone has a little bit of Zoom fatigue. Before I start sharing my screen, I do want to share with you, the emphasis today will be on the Voting Rights Act and placing it in the context such that we can better understand racially polarized voting and how it plays into our Section 2 conversation today. So that'll be the focus. I do want to emphasize and state that I am not an attorney. However, I've been an expert in several of these cases. I've been involved in this. This is my 22nd year and my 3rd redistricting cycle. So I know enough about it. Without being an attorney, God knows I've worked with a number of them. So I will bring their conversation into this as we talk. But again, I just wanted to state I'm not an attorney. So any of the more in-depth legal things, we may want to pull back a little bit. And certainly, as Jose mentioned, provide the question. If I cannot answer the question, we'll certainly get it answered for you. Now, I'm going to share my screen here. And everyone, let me move this over. Everyone should see racially polarized voting background. Give it a second to enlarge. Okay, Jose, can everyone thumbs up? Everybody can see this?
Looks like, yep, getting some.
Okay, all right. So racially polarized voting background, and we're going to emphasize more on the Voting Rights Act today. Let me tell you about the upcoming trainings. This one is specifically focused on the Voting Rights Act of 1965. The next training, data sets and analysis. So again, we're going to set this up such that the 2nd and 3rd training make a little bit more sense. But if you're going to get more into the statistical methods and data sets and analysis, which I will touch on today, we've got to put it in context. And this is what we're going to do today over the next hour. Place it in context so the 2nd and 3rd training will make sense. So in the end, you'll look and go, that's why I remember Fred said that. And I remember that he mentioned this. That's why we're doing this. So having set that frame, again, we're going to focus on the Voting Rights Act today. And the background for this presentation is the Voting Rights Act of 1965, Thornburg versus Jingles, which is going to set up the premise for drawing districts, that first jingle, and the racially polarized voting analysis, which involves the 2nd and 3rd jingles factor. So Thornburg versus Jingles in '86 is the case that set this up for our Section 2 inquiry and potential litigation. And then we'll talk about influential post-Jingles rulings. That'll be our outline for today. Now, let's start with an overview of the Voting Rights Act with the intent, and anybody that's been on a presentation with me know that I talk a little fast. So if you need to, I'll try to go slower. I'll go a little slower. And you also know, if you've done any presentations with me presenting at all, I don't read. I'm not going to read this to you. I think Jose mentioned that this will be available to you after the training. So we're not going to read, but I'm going to highlight some things, but I'm more of a talker. So the Voting Rights Act passed by President Lyndon Johnson in 1965 with the intent to enforce the 15th Amendment. And those of you know the Civil War amendments, the 13th, the 14th, and 15th Amendments, the 15th specifically, the right of citizens of the US cannot be denied based on race, color, or previous condition of servitude. And then section 2 of the 15th Amendment, Congress shall have the power to enforce that article by appropriate legislation. This appropriate legislation is the Voting Rights Act of '65. And I will say, in all my years of studying this and teaching this, one of my favorite quotes about the Voting Rights Act is when Lyndon Johnson told his attorney general that he wanted Congress to pass the toughest expletive bill they could about Voting Rights Act. And that's what they did in '65. They passed a pretty solid and good bill to ensure that the rights of individuals to participate in the electoral process was not denied them based on their race, ethnicity, color, previous condition of servitude. Now, this has been weakened somewhat, but going back to the premise of the bill and then hopefully getting back to it, we can get back to how strong that bill was. Now, section 2 of the Voting Rights Act is what we'll spend a great deal of time really setting all of this up for. No voting qualification or prerequisite to voting can be denied to individuals based on the account of race. That's going right back to the Voting Rights Act and what we said about diluting or weakening the voting strength of minorities. Section 2 applies everywhere in the United States. There is no reauthorization. There is no timeline to it. It's everywhere. So no voting qualification, no standard or practice or procedure can be denied or allowed to prevent citizens of the United States to vote on the account of their race or ethnicity. That's going to set this entire conversation up. Now, with section 2, we mainly talk about vote dilution. And with vote dilution, look at voting like some 47 or more states have passed bills that can be shown to disadvantage voters of color. A redistricting scheme, redistricting plans. We are in the heat of redistricting season, even though we just got the data last August. We're in the heat of redistricting season, and you'll see plans pass. You've already seen lawsuits dropped already, some even before a plan was adopted. I don't understand that. But we're in the heat of redistricting. A redistricting plan can be shown to dilute or weaken the voting strength of people of color. And we'll get into more dilution types of techniques later. But that's going to be something that the attorneys and their experts have to take into these cases. Were minority voters' ability to elect candidates of choice weakened and diminished by some voting bills that came out or by a redistricting plan that can be shown to weaken the voting strength of this group or class of people? Section 2, as I mentioned, we already know by the Voting Rights Act, this law passed to support this, by the Voting Rights Act, and this section passed to support this Voting Rights Act, the Voting Rights Act. The right to vote cannot be denied based on race, ethnicity, color. Section 5, we have to talk about, I used to love to talk about it, now, so-so, required that jurisdictions, areas in the country, some whole states, some parts of states, they would have to get pre-clearance or basically approval by the Department of Justice or the District Court for DC, the DC District Court, would have to approve these changes. So with that, some of these voting bills you saw passed this year and such, if that area was covered under the Section 5, meaning they met some standard in the 1960s, and this bill applies to them, they would have to get permission to, pre-clearance, probably a better word, but I'll say permission, to allow this bill to stand, allow this to be enforced, or even a redistricting plan. It would be sent to the Department of Justice, and the Department of Justice could pre-clear it, meaning, okay, go ahead, Georgia, go ahead, Alabama, go ahead, North Carolina, go ahead, Texas. You see where I'm going with this. Go ahead, we don't see a problem. But if they determined there was a problem, and that problem being diminishing or weakening the voting strength of minority voters, then DOJ could refuse to pre-clear it, and these states or counties, school boards, city councils would have to go back to the drawing board and redo their redistricting plans. So that was Section 5, wonderful part of the Voting Rights Act. But we're going to talk about what happened to it in a little bit. Now, well, actually right now. So Section 5 was intended to provide remedies for voting. And remember, the Department of Justice and or the DC court could bring a challenge, could refuse to pre-clear some particular prerequisite, some particular standard, some practice, some redistricting bill that was passed, some voting bill that was passed. They could stop it. And in stopping it, and in something that I did many times prior to 2013, it really aided a lot of organizations that are probably represented on this call. Lawyers Committee, LDF, ACLU, SCSJ, SPLC. You see where I'm going here. A lot of times we would hear about a redistricting plan, and I'll focus more on a redistricting plan. We would hear about a redistricting plan. We would get a call from voters saying they want to reduce the number of seats in this city council or this county, or they want to increase the number of seats, or this redistricting plan divides communities of color and it weakens or dilutes their voting strength because now these areas are diluted or cracked between several districts. When that happened, we would do our investigation, do our analysis, write a comment letter, send it to the Department of Justice. Because if this area was a covered jurisdiction, they would have to do the same thing. And with that, the Department of Justice responds, because they had a time period, they had a 60-day time period to determine whether or not they were going to pre-clear this plan or not. And with that, we sent comment letters, we sent analysis. They would call us, they would interview us, they would read our analysis, and they would call you, the voters, and ask the voters to explain this particular situation. Then after a while, you could end up getting, now you could get that plan pre-cleared if DOJ didn't have a problem with it. But if they did, it saved a lot of litigation time and effort. So that was really, really important with Section 5 because we felt we had a stopgap. So we attended the hearings, we provided an alternative plan, we showed how you could not diminish minority voters if you went with a better or a more fair plan. We presented that, we went on the record with it, and these jurisdictions, these states, these cities, these counties, these school boards still passed a plan that we thought diluted minority voting strength. So then we ran to DOJ. And DOJ didn't always pre-clear now. It wasn't like that. They didn't always refuse to pre-clear. But if we could show that they did, then oftentimes they did. And this had been the practice from the 60s all the way to 2013. So that was important because it allowed us some time. You didn't always have to jump straight to a lawsuit. You didn't always have to jump to it. And sometimes I remember, did a lot of work in the South. There were a lot of areas where when they heard that a particular civil rights organization is getting involved, it might make them back down on some more nefarious acts because no one wanted to go through the process, be denied pre-clearance, and then have to start all over again, particularly when you're running up against candidate filing deadlines and such. So that's enough about the importance of Section 5. Now, this is just a map showing you all of the areas that were covered. Look at the South. Yeah, that's where I'm from. Look at the South, but look at parts of other states. This is not in the South. So, and you'll see North Carolina areas and such. So it was predominantly in areas in southern states, but in parts of other states. Look at Michigan and others. So that was Section 5 when it was in existence. And here's something to note. Areas that were deemed pre-clearance, it was based on that standard in the 60s that if 50% of the voters didn't turn out for that 1964, I think, election, or if the jurisdiction, the state or the city or the county could show that less than 50% of minority voters were registered, then you were a Section 5 covered jurisdiction. So that's important to note there. Now, of course, you know that the Shelby County decision in 2013 eliminated Section 5. But what people tend to forget in this is that it's not really so much Section 5 as Section 4, because Section 4 established that coverage formula that I just told you about. It was Section 4 that determined that 50% threshold or so in registration and voting. So until Congress can come up with a new standard here for Section 4, then there's no need for a Section 5. So that's that little relationship between 4 and 5. But when we talk about there's no Section 5, there's no Section 5 because there's no coverage formula, which would be explained and detailed in Section 4. Now, so we've got Section 2 in effect everywhere. And even going back to when Section 5 was in existence, if the Department of Justice or the DC court pre-cleared a plan, we could still come back with a Section 2 lawsuit. That didn't preclude any of that. Section 2, still in effect, still in existence. Section 5 is what's gone now, or what's problematic. Shelby County decision in 2013, again, Section 4, you heard Chief Justice Roberts state that, wait a minute, we're using this 1960 standard, 50% voting threshold turnout, less than 50% voter registration. That doesn't apply. Look, 2008, you elected a Black president. 2012, you re-elected a Black president. And that standard doesn't apply anymore. We don't need that anymore. And of course, this was troubling for all of us to hear, because those of us that have been doing this for years and years know that every 10 years we come up against packing voters and cracking voters and all kinds of dilutive efforts. And then any particular time during the decade, we can still see voting laws that really weaken minority groups' ability to elect candidates of choice. Voter ID laws, shortening early voting in places that had them. And now today, all of the additional avenues to exercise your right to vote during a pandemic now diminished and weakened. If we had Section 5 and those areas were covered jurisdictions, we possibly could have stopped it before you get to litigation. Now, without Section 5, everything is straight litigation. So all of these civil rights organizations now, you don't have that DOJ stopgap hope that DOJ can stop it, and that'll save all of this time, money, resources, energy in another lawsuit. Maybe DOJ can stop it, and then maybe that jurisdiction will come back with a better plan that we won't challenge. But without Section 5, and again, it's not in effect. So without Section 5, there is no stopgap. It's straight to litigation. So you're going to see, and again, as I mentioned, I'm sure there are a number of organizations on this call probably involved in some lawsuits, about to get involved in some lawsuits, considering challenging some of these redistricting plans and other voting methods. All of this is going on right now, and it puts a tremendous burden on organizations to be able to keep up with the tons of lawsuits that are coming. These lawsuits are expensive, they are time consuming, and just think about it. A lot of organizations don't have 50 and 100 and 150 people. Some of them are quite small and limited number of attorneys. Many of them may not have a resident social scientist. A lot of them have to contract out, and you've got to pay, which I'm sure there are some people on this call that are hoping to be expert witnesses or already expert witnesses. You are looking at people charging per hour to run the kinds of analysis that you'll be hearing about in the second and third trainings. So Section 5, I think I've spent enough time telling you how impactful the Shelby County decision was. Now, and just to sum this up, look at the African-American registration from 1965 to 1967. Before the Voting Rights Act, 29%. After the Voting Rights Act, 52%. Added to that, a number of minority elected officials across the country. And in the 11 former Confederate states, there were Black members of state legislatures in 1965, three, and by 1985, 176. And of course, we know that number has increased now. So with the Voting Rights Act, there are, the premise in the 1965 was that Section 5 would be reauthorized periodically. So this act has been reauthorized 1970, 1975, 1982, and the last one was 2006. And the 1975 included language minorities, ballots in different languages and such. Now, with the Voting Rights Act in 1980, and see, here's something that's interesting. There's always been challenges in voting, always. I don't think I'll live a day without some challenge somewhere. Always challenges in voting. Mobile versus Bolden in 1980. Supreme Court ruled that for these Section 2 dilution claims, you had to demonstrate racially discriminatory purpose. That's hard to do. Purpose. Congress reacted to this in 1982 by amending Section 2 to include a results clause. And this is where I read to you. No voting qualification or prerequisite to voting or standard, practice or procedure shall be imposed or applied by any state or political subdivision in a manner which results in the denial. So therefore, we don't have to rely on purpose, which again, hard to prove. Now the results. Let's look at the outcome that this standard or procedure has created. So we've got that with the amendments in 82. Then we get to 1986, or a little bit before that, and we get to the case that's going to set up this whole premise for racially polarized voting and such. Thornburg versus Jingles involved Black plaintiffs in North Carolina. With this case, and I'm not going to go into the case, with the case, we come up with what we call Jingles prongs, or criteria or conditions. Jingles 1, 2, and 3. This is what has to be established for a Section 2 claim. Jingles 1 says, or ask the question, is the minority group sufficiently numerous and geographically compact to constitute a majority in that single member district? So if we're going to draw districts, can the minority group be over 50% of the majority in a district that's compact, not squiggling and turning and curving all over the place, but that's compact? If you can't meet that standard, if you can't draw a compact district, the very first Jingles requirement, then there's no need to move to 2 and 3. There's no need, because there's nothing else you can do. Oftentimes I've gone into areas and said, I'm sorry, perhaps the numerical, the number of minorities in this particular area just isn't sufficient enough or compact enough for you to be over 50% of a majority. And there's nothing we can do here in terms of Section 2. You got to be willing to say it if you can't do it. We're going to move on and say, yes, you can draw a majority minority district. That's compact. Now then you can move to Jingles 2 and 3. The second Jingles factor is that minority group cohesive. In other words, do the minority voters tend to support the same candidates? And you can look over a series of elections, right? So we're going to talk about endogenous elections. Those are the elections that involve the challenge. So if we're going to sue a school district, and the school district is a single member school district system, we might look at several elections over the past 2 or 3, right? Over the past 5, 10-year period, and look at a pattern. Do minority groups, do minority voters tend to vote for the same candidate? That's really, really fundamental here, because you've got to show that they are cohesive. And there's a way to do that, which I'll get to in a little bit, but you'll get to more in the second and third training. If we can show that minority voters tend to support the same candidates, then we can move on to Jingles 3. But honestly, 2 and 3 kind of work together. With Jingles 3 is that majority group, and let's just say white voters. That majority group, do they vote consistently as a block, meaning they all vote together for that same candidate, usually a majority candidate? If I can then show that the majority, white voters in this jurisdiction, tend to support the same candidate, and their numbers and their cohesion is so significant that minority voters can never or rarely ever elect a preferred candidate of choice, then I've satisfied my 3 Jingles. So here we are now. Jingles 1, can the minority group constitute a majority in a single member district? Jingles 2, are those minority voters cohesive? Do they support the same candidate? And Jingles 3, do white voters vote in such number together that their candidate always wins and minorities never stand a chance? If I can get to 1, 2, and 3, then we are rolling in this Section 2 lawsuit. I'm not finished, but we are rolling in this Section 2 lawsuit. And let me speak a little bit about 2 and 3 before I move on. You should be asking yourself, is the minority group politically cohesive? Do they vote together? And do white voters vote as a block to prevent the minority preferred candidate from winning? How are you going to find that out? I hope you've been scratching your head going, wait a minute, wait a minute, wait a minute. When I vote, nobody knows who I voted for unless I tell them. So when the state or the county or the city, whomever, the precinct tallies these votes, they don't know that Fred McBride voted for A or B. They don't know that. They have some data on me. They've got my address. They probably have my party affiliation. They've got my race. They've got my sex. They've got all of that. But how do they know who I voted for? So Fred, how are we supposed to know that minority voters all tend to vote for the same candidate when there is no way I can get an election return and look on an election return and see who voted for who. So that should be a question. Then the next question, how are we going to show that white voters all voted for that same candidate when your ballot and that election tally in the end does not have your name tagged to it and your identification? So therein lies a problem for the next two trainings. It's called an ecological fallacy. How are you going to take group data, aggregate data, election returns, and in those election returns, not knowing who voted for whom, just knowing who won, and maybe you know something about that precinct. We can go to census data, we can go to some state data, and we can know the racial and ethnic classification of the voters there. We can know their gender, sex, we can know their partisan affiliation, we can know all of that, but we don't know who voted for whom. That is a part of this secret ballot system that we have here, and it's good that we have that. So then there's a problem because you're going to take this group data, this election return data, and then you're going to infer how an individual voted. That's termed an ecological inference problem, but we've got a way to solve it. We solve it, which you'll get more into in 2 and 3. I can't get into it in this training, but with that problem, we are going to take those election returns by precinct. We are going to find out about that precinct, the racial and ethnic makeup, whether we use census data, whether we use state data. State may have voter registration data, and or we can also, depending on the state, we can get election returns and we can get the voter and the voter's address, and we can geocode them down to a precinct, and we can figure out from there how many people voted. Only thing is we don't know who they voted for, but we've got the outcome. So here's this massive data: election returns, census data, state registration data, and if you're lucky, geocoded data. And we are going to infer through some very complex statistical analysis, we are going to infer that Black voters voted for this person, white voters voted for that person, Hispanic voters or Asian voters or Native American voters. We are going to infer with relevant data that we have collected, we are going to infer how an individual voted. This is not precise. It is not at all precise, but it is a very good indication that we can meet Jingles 2 and 3. I hope I didn't confuse you with that, but that's Jingles 1, Jingles 2, Jingles 3. Now, I went through a lot of this, so I'll move on. 2 and 3 are really what RPV, or racially polarized voting analysis, is about. Jingles 1, that's a demographer, that's a mapper, mapping, drawing that district. And we've been teaching communities and groups, and a lot of people on this call have been involved in teaching them how to draw districts. 2 and 3, a little bit more complicated, but I expect that Redistricting Data Hub and others will be assisting in training for this, because you're going to have another training specifically on RPV analysis. But that is statistics. No, you don't have to be a statistician, but you're going to have to learn a lot and some basic, some a little bit more complicated, some programs like R and such, in order to perform this analysis. So I'm going to leave it at that, because again, you've got 2 more trainings coming and I need to get through this one. So I think I've given you the background for Jingles, Thornburg v. Jingles, that's the Jingles criteria. Even with that, even though that's a good standard to determine your section 2, we're still not done. There's something called totality of circumstances. If all 3 Jingles conditions are met, then the court is instructed to look at the totality of all of this, which includes 7 other additional things that your expert is going to have to do, or experts are going to have to do in order to meet this. History of voting-related discrimination. That can involve going through this jurisdiction's record since it became a city or a state. A history of discrimination, that's one. Racially polarized voting, which we've discussed, that's the second one. The extent to which state or political subdivisions use practices or procedures that tended to enhance the opportunity to discriminate. Things like prohibitions against bullet voting. Remember back in the 50s and 60s, if there were multi-member elections where there's a district, but let's say 3 people are elected out of that district. So when areas had, let's say a group of minority voters wanted to see that minority candidate elected. So there was 1 minority candidate and 2 white candidates voting, or let's say 1 minority candidate and 5 additional white voters running for a seat. And in this particular seat, 3 candidates can get elected. So minority voters could vote for the minority candidate and then vote for 2 of the other 5 non-minority candidates. But bullet voting, minority voters said, you know what? We're helping defeat that minority candidate. So what can we do? How about we just vote for that minority candidate and not vote for anybody else? That increases that minority candidate's ability to get elected. That was called bullet voting. Well, some places have prohibitions against that. So if minority voters wanted to bullet vote, there was a prohibition against it, and they weren't allowed to do that. So when you can show these types of discriminatory practices, that's the third totality of circumstances. For the exclusion of members of a minority group from candidate slating, you see this before every election. A party comes out with a mailer and says, vote for these candidates, but they're minority. There's a history of minority candidates being left off, even though they were members of that party. That's excluding them from the candidate slating. The extent to which minority group members bear the effects of discrimination in employment, education, health. Go to your ACS data in the Census Bureau, American Community Survey. You can get education statistics, employment statistics, and then sometimes go to that jurisdiction, go to that school board office, and attorneys work all of this out in litigation and discovery, what you can get, what you can have access to. And you're looking, what you're trying to show is that minorities have been hindered in participating in the electoral process, and that effect, the discrimination, all of that kind of skewed into education, employment statistics, health, demonstrate all of that, a number of resources available to help with the 5th circumstance. Number 6, the use of overt or subtle racial appeals. Let me go to this flyer. Look at this in 2008 by the McCain campaign, darkening Barack Obama's face. And then a candidate here on the right side, darkening her opponent. You know that's subtle and overt racial appeals. And you can find this. You don't even have to leave your home. You can find it all on the internet now, although I have gone out and taken pictures of signage and all of that campaign material that you know has that hint of racial appeal to it. And then 7, the extent to which members of a minority group have been elected to public office. If minorities are winning in these elections, you don't have a case. You don't have a case. Now, if they are consistently winning, so you're going to show that through this period of time, I don't know, it could be 6 years, it could be 10 years. I once worked for someone that wanted to go back 20 years. Show how difficult it is for minority candidates to get elected. Once we go through those totality of circumstances and you meet all 3 jingles, I would say, aside from the challenges your experts are going to get in a case, you've got a fairly strong Section 2 case. I didn't say you was going to win it, I said you got a fairly strong Section 2 case. So that's the totality of circumstances. let me briefly go over some post-Jingles rulings. Shaw v. Reno back in the 90s, early 90s. Basically, look at these districts. This was out, again, North Carolina, one of our favorite redistricting places. When you're drawing in that very first Jingles condition, the district needs to be compact. So in other words, race cannot predominate the process. Your demographer can't go in with the mindset, I'm just going to pick up as many Black voters or Hispanic voters or Asian voters or Native American voters as possible, draw it any kind of way, and I satisfy Section 2. Or I satisfy the first Jingles. No, that's a Shaw violation. You don't want to do that. Your districts need to be compact, and race cannot predominate your process. Johnson v. DeGrady. Here, Section 2 does not require maximizing the number of districts. So with this, your demographer can't just go into a mapping situation and just start drawing as many majority-minority districts as possible. We got to consider proportionality to a degree. It may not be the rule or standard, but to a degree. And remember, the Voting Rights Act, we went through Section 2, we went through Section 5, we went through Section 4. I didn't say anything about creating as many majority-minority districts as possible. That is not what the Voting Rights Act, that is not the standard in the Voting Rights Act. Just go create as many majority-minority districts as possible. So this case pretty much establishes that. And then Bartlett v. Strickland, go back to Jingles 1, drawing a majority-minority district. That majority-minority district must be comprised of 50% or more of voting age population. That's voters that are 18 years or older. That's the standard here. And now we're moving into citizen voting age population. Because of the American Community Survey data and our method to aggregate or disaggregate that data, we can get a citizen voting age population. That's voters in a jurisdiction that are not only over 18, but they are citizens, okay? And that's kind of the standard that we're moving to now. So in conclusion, I think we got the Voting Rights Act pretty much well established here. Thornburg v. Jingles, don't just think about the 3 prongs, although they are the most important. Remember, there are Senate factors that go into it. Once you do those 3, you are not done. And then those rulings, those cases after Bartlett, Grady, and the Shaw cases, those are all taken into consideration. The upcoming trainings, because I touched on it, maybe a little bit more than I should have, but I touched on it. Your second training is data sets and analysis. Remember I talked about census data, geocoding addresses, election returns. You'll get a more in-depth training there. And then the statistical methods. You'll hear R and those types of analysis in the third one. And I'm going to stop there. I ended up talking a little fast in the end, but I'm going to hand this back over to you, Jose. I kind of went over time, but hope we're okay.
No, all good. Thank you so much.